I move. Thank you, Can Corlia. As you've said, we'll take Amendments 1 and 2 together. The amendments to subsection 1A and subsection 1B are basically technical, and they are there to make sure and to make it clear beyond any doubt that any restrictions on publication only relate to the protection of the interests of living children. They are being proposed following a careful review of the drafting and to provide for a scenario, firstly in subsection 1A, where there might be 2 deceased children, and in subsection 1B, where there might be 2 victims, one of which was a child at the time of the offence, but an adult at the time of the proceedings, and the other victim was a deceased child. For example, the existing draft of subsection 1ABI might be viewed as bringing a second deceased child back within the scope of section 252 and preventing the naming of either deceased child, which is not the intention. So if just even to simply put it in page 3, line 21, to delete another child and to substitute this with another child who is alive. When we talk about the best interests of the child, we're not talking about the deceased child, we're talking only about a living child. So this is simply technical. It's taking on board maybe points that have been made in this House, but also in the Seanad, to put beyond any reasonable doubt that this is what we are speaking about in any scenario. Thank you.
Thank you very much, Minister. Anybody else offering on these 2 amendments, 1 and 2? Deputy Howland? No.
General agreement on them.
General agreement. Okay. Section 1, amendment number 1. In the name of the Minister, is it agreed that the amendment be made? Agreed. Amendment number 2, again in the name of the Minister, is it agreed that the amendment be made? Agreed. Amendment number 3 is in the name of the Minister. Minister, to move and address.
Thank you, Ken Corley. Again, this is really to put beyond any reasonable doubt queries that have been raised by deputies in the House, but also senators as well, who are specifically concerned that the bill might be misinterpreted or cause confusion as to the flexibility that the court has where there is a deceased child victim and another child victim or a child witness to the proceedings. The Attorney-General, and we asked them to look at this to reflect on the wording and to reflect on the drafting, and they have recommended that we could change and make these amendments to try and clarify the matter. Before the case of the EC case in October of 2020, I think the general view of all of us is that Section 252 of the Children's Act did not prevent the publication or the broadcasting of material that might identify a deceased child unless it would lead to identifying a living child who is also a victim or a child who was a witness in the criminal proceedings. And even in that instance, there are situations where that can be overruled, or where there can be a naming of a victim, or where there can be naming in that instance. The purpose of this bill is obviously to restore that position and to make it clear beyond any reasonable doubt. Subsection 1A does this by disapplying or removing the restrictions in proceedings which relate to the death of a child, subject to exceptions that I've already mentioned. So just to give 3 scenarios. So if there is a deceased child, if there is no other child involved, then there are absolutely no restrictions on the naming of the deceased child. If there's another living child who is perhaps an accused or who was a witness in the proceedings, then there are no restrictions unless the naming of that deceased child could identify the living child. But very importantly, after that, if naming the deceased child could identify the living child or the accused or the witness, the court themselves must decide whether the deceased child can be named and subject to what conditions. So it's not an absolute, if naming the deceased child could potentially identify the living child, whether they are an accused or a witness, there will be a provision for the court, for the judge to decide, and that's obviously putting the best interest provision first, where we must apply that, but it doesn't trump everything. So there needs to be a balance, whether it's public interest and obviously taking into account whether it's family requests or other scenarios as well. The amendment to subsection 2, as I've said, is to clarify that the restrictions on publication do not apply to deceased children, subject to the exemptions that I've just outlined, relating to living children who are victims, witnesses to the proceedings or accused. It also addresses the more complicated situations where there is the interest of more than one child that needs to be taken into account. And again, referring to my initial amendment, we're talking about living children in this instance. Subsection 2 only applies if there is a danger that the publication or broadcasting of material might lead to the identification of a living child who is a victim, witness to the proceedings or accused, and the court has to consider where it is appropriate to dispense or to remove or to relax these restrictions. The existing subsection 2 and the proposed subsection 2A are both being replaced by new subsection 2A and B. Subsection 2A deals with the proceedings relating to the death of a child, and this is where there is only one child involved. The word shall is used, imposing an obligation on the court to dispense with any restrictions relating to the deceased child, again unless the interest of the living child who is a witness in the proceeding or an accused will be affected. The court then has to consider the matter and, for example, assess in the case of a child witness whether there are no conditions that could be imposed. They might decide that there are conditions that could be imposed, and then separate to that section 93, which exists separately and which we're not trying to amend or change here. This relates to an accused child, and there are already provisions under the Children's Act whereby the first response is that you don't name the accused child. However, there can be certain circumstances, whether it's public interest or otherwise, where that can be allowed. So we're not changing or amending that, and that will still apply. Subsection 2B deals with the proceedings where there is no deceased child, so where you might have a child victim but where they are alive. And again, this is left to the court to decide whether it's in the best interests of the child, if there is a sibling, if there is a second living witness or a child involved in this. Again, the court must take into account the best interests of those children. So really the amendments that we're putting forward is to put beyond all reasonable doubt that there is flexibility there, that when there is a deceased child, but in particular whether there's a living child, whether it's a witness, whether they are a potential perpetrator or a victim, that there is flexibility still to name the deceased child. And obviously we must allow the court to take those conditions on board, but it's to put beyond reasonable doubt and to acknowledge that deputies had raised concerns about this. The whole reason we're introducing this legislation is to clarify perhaps different interpretations of what existed and to bring it back to what we thought it was. And we don't want a situation where we're coming back having to re-clarify where we could have done it in the House here in the first instance. Thank you.